Good evening. Hello, everybody. Good evening to you all. It's good to be with you.
You want to just wait? We got another 3 people coming in, Ava. So I'll. Some of you know Ava, and those of you who know Ava, like I do through our reflective practice group, are really looking forward to hearing Ava because she's got so many wonderful stories and sense of humor, and I was lucky enough to have a preview of this talk, and I'm really looking forward to hearing it again, so it must be good. So Ava, over to you.
I can never live up to those expectations. I will try, but it will be tough. I want to tell you a little bit about me so you can put everything I say into context. One is I am an American. I am married to a Brit who is Brit from the bottom of his toes right up to the tip top of his head. His name is Neil Rackham. He graduated from Sheffield, and he would be a northern mediator. Instead, he's a social scientist who studies interactive behavior. But before that, before I married Neil, I have not been able to hold a job. I have worked for the mayor of DC. I worked for Senator Kennedy on the Judiciary Committee. I was an assistant United States attorney. I was deputy general counsel at the American Institute of Architects. I was vice president of a professional liability insurance company. I have been mediating since 1979, and I have been teaching since 2002. In other words, I have a tendency to see every phenomenon from every different side of my own experience and from my reading. Now, I read a lot, perhaps not as much as I should, but I have found that most of the reading on Impasse is from the mediator's perspective. And I discovered that after my first Impasse. Now, there is a poll for you to fill out. And so I would appreciate if you let me stop talking so you can fill out.
Not yet, I'm just correcting the poll. So do you want to just talk a little bit more? 2 more minutes?
Well, I'll tell you a little bit more.
Yeah.
I was, but then that will just screw up the poll, because what I do is do a poll at the beginning of the session and a poll at the end. See,
okay. So let's just have the one that's got the misspellings in it then. Yeah.
Yep, just send it out.
Okay.
Or else, Nancy, you and I are at impasse.
Oh yeah, there we go. Okay. Okay, can everyone see that poll?
And here's the question. Thinking of an impasse in any one of your mediations, what do you think caused it? Difficult disputants, difficult lawyers, you yourself, or something else? So just, let's see what it says.
7, 12, 14, 15, 16, 17, 18, 20. Okay. We've got 23, that's great. So if I end it and then we share the results, can you see the results there?
Yeah, I can. Can everybody else?
Yeah.
So 70%.
Disputants. Disputants are awful and lawyers are not nice either. So 83% were blown by disputants and lawyers.
And 22 by other. Yeah. And 9% by me. Okay, so I've just jotted this down. Yeah.
Thank you.
Okay.
It reflects the reading. Most
I would say that is more than 100%.
Yeah, it's rounded up. Or maybe people chose more than one.
I think they did. And they can't unchoose.
16, no, we got 16 and 5 is 21 and 5. Yeah, never mind.
I think the enumerate are a major cause of the impasse.
Yeah, well, there you go. That's scientific. Anyways, it gives us a general idea, doesn't it, Ava?
And indeed, that's what the writing talks about. That it is usually difficult people who cause the impasse, usually disputants or their lawyers. And I used to believe that completely until my first impasse. It was caused by me. In the morning, I was a questioner. I sought information, fact. I sought information, feeling. I tested for understanding. I summarized what they said. I got sign off on what they said. It was all going swimmingly. And at 4 o'clock, I realized that it wasn't going to settle by 5 unless I did something. So I decided to do something, and I changed my behavior from the nice questioner to someone who is more, you should be doing this. Have you been thinking? And suddenly I had become a stranger to the disputants. And since it's always easier to say no than to say yes, in the lack of consistency, they did the only wise thing that they could have done, which is to say no. And that was the end of the mediation. I had caused it. And it took me a while to realize that it was the inconsistency of my conduct that caused confusion to the disputants. Now, maybe they were difficult people, but it is easier to blame difficult people than it is to figure out what part you played in it. And the only person at the mediation table that you can is you. And so, partly because of the type of person I am, I took full responsibility for the impasse. And I accepted, notwithstanding that difficult people cause impasse, until I myself became the difficult person. My husband and I had a farm. We sold it to a conservationist who ended up being a shill for a developer. Much to our shock and amazement, we were still willing to go through the deal, but we had all these promises that the person had made, and we assumed they would live up to it. They called our lawyer, they failed to disconnect, and we heard him say, promises, schmomises. I come from New Jersey. If they don't like the way I do business, they can call the police. So I said, well, you have a choice. You're going to be sued by a bad person or by a poor people that we're trying to protect. We chose to be sued by the developer. And the net effect of it is I got to learn what it was like to be a disputant. It is not fun, particularly if you go through years. Our case took 5.5 years to settle, and then we got sued by the broker for another 3 years. And you feel that you're on the right side of history, and it just goes on and on and on and on and on. It is relenting, unrelenting. So I sat there and I thought, I have become the difficult person. And I called my boss, the head of the mediation program at the DC circuit, and I said, I have a mediation and the person is just impossible, awful disputant. And she said, well, tell me about the disputant. And I said, she looks an awful lot like me. And since she knew about the case, she said, take your victim hat off and put on your mediator hat and see what you can do. And then I realized the intensity of the angst of a disputant. And that was what was keeping them stuck in the dispute, in their anger, in their fear. It was that. And my problem as the mediator was I had not geared into that. So it made me get real that in a mediation, when a person is in that state of a flurry, we're asking them to set aside their limbic system and put on their thinking system, and they can't. It is just too much of a stretch. They can't do it. So I realized, okay, I have to erase my slides now. Let's see how, share screen.
Share screen.
There they are.
There you go. That's great. We can see them fine, Ava.
Thank you. It made me realize that disputants have to make very high-risk decisions in a very high-risk situation, totally uncertain of whether any decision is going to be implementable and what's going to happen next. That is asking an awful lot from people, maybe too much. So I began to realize that the role of the mediator, why is it not, is to deal with the human risk that they're facing, not the legal risk we always talk about, the very real human risk that they're facing. How are they going to let go of this case when they have no idea what's going to end up in between? Someone raised his hand and it just went by too quickly. You want to ask?
Jax?
No, that was an error on my part.
Okay.
My kind of person. Thank you. Thank you. And so it made me realize that human risk was the elephant in the room. We're not trained to deal with it. We don't know how to deal with it. Indeed, Ken and I have been coding mediations. And the last time we coded, out of the 35 mediations we coded, most of them lawyers, but not all lawyers, no lawyer asked a question about feelings. They only sought fact. That's pretty amazing, because if you think about it, they need two things to make a decision on their dispute. One is understanding and the other is confidence. They have to understand the situation they're in and the situation they could be in, and confidence to make a decision about which way they want to go. Well, what are we trained to do? Discuss facts. And that may help with understanding. But what's going to help them move? Confidence. And that requires that their feelings be recognized, respected, and dealt with. So instead of looking at the person as a difficult person, making it hard for you to settle the case, look at the person as a person who's afraid and doesn't know which way to move, and see what you can do to lower their anxiety, help them learn and to control or manage the risk so that they are free to move on. So here's the decision-making process. This is not me. I got this from a book that my husband wrote called Major Account Sales Strategy, in which he said that people go through a decision-making process, and it's complicated. You can't push it, you can't make it go faster, but you certainly have to recognize it so that people can go through the process safely and come out with a decision they can live with. So what it ended up doing is changing my way of thinking about mediation totally. Because when I thought this, I went, son of a gun. That's what disputants go through. First thing is they have to recognize a need to move. Let's take it out of mediation totally. Let's put it into something that we all know about. Do you want to change a job? You have the job of your life. You are just so happy in the job. Headhunter calls you, offers you a job, a little bit more responsibility, a heap more money, but you have to move from northern England down to Portsmouth. You sit there and go, Portsmouth, I have the most perfect job in the whole wide world. I'm not moving, no recognition of need to move. I'm happy camper, I'm staying. When that happens, the person is stuck at the very beginning of the process. And we lawyers are trained to say, but you could lose in court. Lawyers are trained to say, but do you have any idea how much this is going to cost you? Those kinds of questions. Instead of saying, what is keeping you where you are? Why don't you want to move? That question of why don't you want to move can bring new insights into the person. So for example, he goes home and he says, I just got offered a job, twice the amount of money, and I turned it down. And she said, you did what? And suddenly there's a need. Suddenly there's a need. And so he sits and talks to his wife, to her husband, whatever. And the person says, you know, maybe we should look into this. Maybe we're not ready to jump, but maybe we should be ready to jump. Let's look into it. And they go to the next thing. They evaluate options. Because there are reasons to stay put, there are reasons to move, and all the zone of opportunity may be bigger than we ever thought of if we work with people to start brainstorming. I had one situation where a woman had been run over by a bus. And I said to her, what is it like to be run over by a bus? She said, I hate my life and I want to change it. And I said, what's stopping you? She said, I don't have money. I said, let's work this one out. And went to the bus company afterwards and said, how would you like to help this young lady start a new life? and the case got settled. Never ever talked about responsibility, liability, or anything. I talked about her and her needs and what she wanted in life. And through that process, she recognized her needs, she evaluated the options, and then there was one more point in the resolution of concerns. And her concern revolved all around money. And so we figured out a budget for the year, how she could do what she wanted to do, and they were willing to pay for it, and she moved on. It is important to recognize that each one of these phases affects everybody in our real life and in the disputant's life. And sometimes an issue comes up late and the person is thrown back to recognition of needs. It's not as if you go through recognition of needs, then evaluative options, then resolution of concerns, then a decision. It may be issue by issue, depending on when it comes up. And you may find someone who you thought was ready to decide suddenly getting very cold feet because there was something else they hadn't talked about that was stopping them from moving. But this basically is what they go through. And in order to get past each one, you have to figure out what is stopping them. So for example, recognition of needs, they may not be ready to give up their past because remember, the lawsuit, the whole focus of the lawsuit has been on them. In a discrimination case, that's a lot of power for someone who has been run roughshod. And so they may not be ready to give up the case. You have to help them work through that so that they can move on to do evaluation of options. So that is basically the process. What fascinates me is that in doing it, people stop at decision, but implementation is real. It is a major concern of the disputant. And indeed, if any of you have read Rackham and Carlisle's piece on the communication behaviors of expert negotiators, right before a decision is made, they focus on implementation. If the agreement is going to fall apart, let it fall apart at the negotiation table so they can pick it up, dust it off, and make sure it can succeed. Implementation runs through their brain all the time. And as a mediator, it does mine also. Indeed, one time I had a case, it was 20 years old, and there was just one fiddle at the end. And they were all upset about the fiddle. And I said, why? You settled this, you settled this, you settled this, you settled this, you settled this. This is a fiddle. Put your heads to it, see what you can do. The job of the mediation, to me, changed. And it began to be to help the parties through the decision-making process so they can make a decision they can live with because they're going to have to. And it is a very different way of thinking about mediation than the way we've been taught. And so therefore, Nancy thought, this is a hoot, let's present it to them and see what they think. And this is an interactive session. I would like very much to know what you think, because our research is going to look into this and someday we'll have statistical data to prove that this is correct, or alternative to prove that I'm blowing smoke. So what ends up happening after recognition of needs and someone understands they have a problem and they have to solve it? This is what happens in the best of worlds. You ask questions. You say, they have to recognize they have a need to change. So they're thinking, do I have a problem? How serious is it? What benefits would I get from solving it? And as a mediator, I always say, you know, you have a case here. Do you want to settle the case or do you want to resolve the problem that produced the case? Settle the case is hard because they don't want to admit failure. They don't want to admit this. They don't want to admit that. And they don't want to give up the case. But the carrot is, do you want to resolve the problem that produced the case? And you would be amazed at how many disputants say yes and how many lawyers say no. But getting everybody on the same page so that someone is willing to give up the case, to recognize that it's time to move on, is a very big first step. But what do? We don't help people through that phase. Once we understand that they have a problem, we so very often jump to solutions. We go, I know how to solve that. Why don't you do this? And the person who doesn't even know that they have a need is suddenly given a solution for a problem they don't know exists. So why do we do it? Well, one, it makes us feel that we're adding a lot of value. Because we were trained, that's what we're supposed to do, solve problems, so we'll solve yours. Two, we want the whole process to move forward. And by giving out a solution, they have something to talk about other than the dispute. And parties expect to talk about solutions, not in the first half hour, but they expect that sometime we'll be talking about solutions, so they're prepared. It's easy to do, we get away with it, we get very good at it. And if we have a really great idea, we can't wait to talk about it so that everybody will buy it and say, wow, he's so smart. We're so lucky to have her as the mediator. But what ends up happening, if you present an idea too soon, before the person understands they have a need, before the person understands that there are steps to go through, they're not ready to hear the idea. So what they say is no. So, want to avoid impasse? Don't jump to solutions. Let the disputant work his way through the problem at his speed or her speed, not at your speed. Now, I know from Nancy, I know from our practitioner group that you have more timed mediations than we do. You have to settle it within 4 hours. And maybe they can do this or maybe they can do that, but time is more of essence from what I've heard. But it's still not a reason to do what I did, is to start pushing so that people end up saying no, especially when the case could have been solved. In fact, too fast solutions lead to objections, even when the idea that was put on the table is great. And indeed, once you put it up and it's been rejected, you can't bring it up later at the appropriate time when it would have been accepted. So don't jump to solutions. It's the easiest way to avoid impasse. Now, step 2 is decision-making. It's evaluation of options. The person is ready to move, but they don't know how, and they don't know where, and they're not quite sure what they want to, and they're going to sit and think of options. When a disputant is in a risky situation, in a highly intense situation, they don't have the freedom to think about options. And it's very hard to ask them to think about options, but they have to work it through in order to figure out where they want to go. And very, very often I go, you know, you seem stuck. Do you have any ideas at all about what's available to you? No. Is there anyone who could help you on this? I mean, I'll be willing to help, try. And the person often says, I need to speak to my partner. I'd like to know what they're thinking. And what they need to do is give themselves permission to think about options. And once they've given themselves permission to think about options, it is amazing how creative they can get. I had one case, it was a foreign policy case where we had the ambassador, the Department of Justice, the agency that was involved, and everybody was frozen. Everybody was frozen. And I looked at them all and I said, you know, you're all mediators. And I looked at the ambassador and I said, sir, you're represented by a mediator, and Department of Justice is represented by a mediator, and the agency is represented by a mediator, and I'm a mediator. Would you give us permission to go outside and brainstorm and come back with all kinds of ideas, and you can select the one that you want, or alternatively, create another one, and let's see where it takes us. He said, go for it. And we did. We had 5 options on the table. The first question was, how can we make them stronger? Second question was, what are their weaknesses? How can we cure them? Third question is, do you think your party would buy it? Fourth question is, 5 is too many to consider. How many do you want to go forward with? They went forward with 3, and the case was resolved that afternoon. So generating options is hard, but it has to be done so that they can make a decent business decision that they're going to have to live with. Key issue at this stage, is which alternative is the best. This is where BATNA comes in. And very often people don't have a BATNA. So it's you who's going to have to start creating options with them so that they can have a BATNA. Which option is cheaper, they may ask? Which one is better? Which one can I sell to my board of directors? Which one will give greater success to the group? And can you help me brainstorm? Because I'm stuck, and see if there are other options we can develop. So this is a chance to free people up, to see that there's something better than their lawsuit, better than their past. And they have the power and the control to start going about creating it. Want to avoid impasse? Don't fall in love with your own solutions. Be as creative as you possibly can in helping people figure out what options are available. Any questions so far?
Do you want them just to unmute and say?
Yeah, sure.
No, any questions?
Ava, does this apply to all sorts of mediations, do you think? For example, under our model in family law, whatever solutions they come to, they're not legally binding, which is designed to remove some of the fear.
Let me repeat back to you what I hear you saying, just to make sure I understand it. In England, in family law, nothing is legally binding because it increases the chances parties will agree. Is that what you're saying?
So I didn't hear the last bit you said. Well, it's just not legally binding at the end of in the mediation. It's one of the principles of mediation. It only becomes legally binding once they see their lawyers and decide to make it legally binding.
Oh, good. I'm glad I asked that. Yes, it's the same thing in the United States. Only in the United States, very, very often, people are represented in family situations. And in England, they may or may not be. So that, that's a big difference. So now I'll ask you a question again, since I'm a little bit smarter because of what you taught me.
Now, I was wondering if, so it applied across all types of mediation.
Okay. I don't do family law.
Right.
And so I can't answer the question from my own experience. Ken, I don't know if you coded enough people, and we weren't looking for it when we were coding. And Nancy, you do mostly family law.
No, I do special educational needs mediations, which are legally binding, the agreement. But I think looking at it as a framework, we're looking at it from your mediation skills.
Yes.
So in terms of avoiding an impasse, I would think it's applicable not just across mediations, but across any situation where you're wanting people to come to agreement. Because like you were talking just about the job situation, how you work through that. But I'd be interested, Michael, in, do you think it wouldn't be applicable in family?
Well, it was really on the risk, I think, Nancy, towards the beginning, and not knowing being afraid of the implications. Quite often it's fairly limited as to whether a house is going to be sold or not, and where the parties are going to live.
Michael, let me help you on that one. Very often people are frozen because they don't have enough information to make a decision. And so instead of brainstorming ideas, you can brainstorm what they need to learn in order to be able to make a decision. And this happens on everything. When you mentioned selling a house, I have a cousin who's trying to figure out whether they should move. And I listened to her, and she's running around in circles. And this is like the third time we've had the same conversation. And I said to her, you don't have enough information to make a decision. Why don't you go start looking at houses, looking at apartments, and figure out whether you want to move. See yourself in different situations and see how it feels. So that's an alternative that's available. just another way of helping people unstick themselves. But recognize.
That's helpful, thanks.
Thank you. The next stage is resolution of concerns. So the questions you're going to be asking here is, what are the risks of going ahead? Can I take them? Can I mitigate them? Can I erase them? How am I going to deal with them? Are the risks too big? Or the risks just silly? So some of them are, what happens if they screw up being a legal term in the United States of America. Can I trust their claims? What's in it for me? What's in it for my boss? You know, and then finally, in America, how will it read if it's on the front page of the Washington Post or the Wall Street Journal? What will I tell my family and my friends? What will they say? All of this is real. Some of it is fact, but some of it is pure feeling. I want to buy it. Can I sell it? I think it's a great idea. Will the board think I'm crazy? Will I get fired? In the 1950s, in the 1960s, there used to be a saying, nobody gets fired if they buy IBM. It was a risk issue. And IBM had such a presence that if it didn't work out, well, you went the safest route possible. So part of this is fact, part of this is feeling, and most people aren't sure which one is it. So in decision-making, you have to understand that same word will mean different things at different stages. I'm going to use architects as an issue since I know architects so well. When an architect hears you're too expensive, the first thing you want to do is lower their price. Now, at the recognition of need states, what the disputant is saying is, given what I think my needs are, you're too expensive for the need. It ain't worth it. And so there, it's a question of helping the person recognize what his needs are, because they may be indeed much larger than what they're thinking of. And then the architect is not too expensive. Evaluation of options, your competitor is cheaper. At which point it's a question of the architect not being able to present himself in a way that the other person thinks it's worth the money to buy him. And a resolution of concerns, it's too risky. And so when you have a recalcitrant disputant in front of you, try to figure out where they are in this process. And if it's resolution of concerns, it's because it's too risky for them to move forward. And it's a question of saying, something's stopping you. Do you know what it is? And how can we deal with it? Because I don't think people are recalcitrant. I think they're afraid. So, want to avoid impasse? Seek information, both fact and feelings. And test understanding and get sign off that you did indeed understand. You know, we teach active listening all the time. Seek information. Make sure you listen and understand, and then go forward. The problem with that is that's all about the mediator. And I teach my students, you have not listened until the speaker says that you have heard. That you have heard what they're saying in the way that they're saying it. That they're telling you, you got it. And it doesn't matter on your first time whether you got it or not. You can say, oh, I'm so glad I asked. This is important to you. And if it's important to you, it's important to me. Would you try me again? Not everyone is articulate. And help them work through what they're trying to say. Get sign off when you do understand and they agree that you understand. And the last one is label your behavior. There's a lot written about the need for mediators to be transparent. About process, about procedure, about substance, about this, about that. Labeling your behavior is the key to being transparent. I have a question to ask and follow it up immediately with a question. I want to test understanding. I'm not sure I get it. Or I spoke a very long time and I'm not sure I made sense. Do you mind if I ask you, what did you hear me say? Person says something that you had not said, you could say, I am so glad I asked. I have no doubt I said it, but it's not what I meant to say. Would you mind trying me again? And then make sure you get sign off, make sure you give sign off so that you have shared clarity. Because your goal in a mediation always is shared clarity so that you're talking about the same things, you're understanding each other, you can move forward together. So labeling your behavior, I have a proposal to make. I have a question to ask. I have, we've talked about so many things. I'd like to summarize what we've already decided. Make sure you label your behavior. It'll make it much easier on everybody. So that's where we are. And what reason I am stopping right now is because most mediators think when we get an agreement, it's done. But the poor people have implementation left. And so absolutely, before they make a decision, say, all right, let's play it out. What's going to happen the next day? How's it going to work out? And test the agreement to make sure that will stand up to implementation, because that is yet another way to decrease the risk facing the people. So, want to avoid impasse? Respect their senses of consequence. Don't label the person difficult. Know that something bad they're afraid of is going on. So don't minimize them. Don't prescribe solutions. If I were you, I would do this. You're not they. Give them freedom to work it out. Pushing is not going to help here. Pressure is not going to help here. What it is an opportunity to think it through. And on giving them the other to work it out, very often I say to somebody, something is stopping you. Do you know what's stopping you? And one person said, I need my wife. Invite her here. We'll take a break, invite her here. My boss will kill me if I go down that route. Want to talk to your boss? I mean, help them figure out how they want to manage the consequence and give them the opportunity to do it. So, any questions so far? Is that a yes? Okay. Now, each party has their own road to hoe. And one of the problems that you have in any decision-making process is something crops up and someone is in one place and someone else is in another place. Let's say you have party A, they don't think it's a problem, and party B has already evaluated options, is dealing with concerns and really wants to move. This is a perfect time for caucus. I mean, I used to do it all, keep them all together all the time. But when I read this and when I realized that this was an opportunity for caucus, I started using group strategically and caucus strategically. Because here you can go off with party A and help them recognize needs and move towards evaluation of options without B thinking that A is difficult, clueless, impossible, dumb, whatever. So you're giving everybody the freedom. And you don't have to do it silently. You can say to the B person, you know, they're having trouble and I want to help them out here, you know, and I'll come back. We'll see what we can do. So, want to avoid impasse? Think about caucus and joint, not as habit, but as strategic decisions, and see where it takes you. So, I want you to see these, which basically sum up what we've talked about today. And to ask you, look at what you said before about what caused your last impasse and see now whether you agree that it's due to the disputant, the lawyer, or other. Go ahead, Nancy, can they fill the same thing out again?
Oh, except I've got it right now. Here we go. Can you see that?
Go ahead, fill it out again and see if there's any difference.
Okay, I got 16 participating, right, 21. Is that everybody participated that? Yeah. 22.
So it did make a difference. And for all of you who think I could have done better,
Wait just a sec. I'm going to share the poll so they can see it as well as us, because at the moment
oh, I see.
we can just, okay. Right. So now they can see the result as well. Can you?
Can everyone see it?
Whoop. So we've got 17% difficult disputants, which is down from 70. Only 4% difficult lawyers, down from 13. Me, I could have done it better, going from 9% to 61%. And other is about the same. So I don't know if you want people to share what the other is, Ava? Or...
Oh, if not in group right now, you have my email address. It's AVA. I give the law school address, A Abramowitz @law.gwu.edu. Tell me, this is hard what we're trying to do, and anything you can teach me would be richly, warmly appreciated. That would be terrific. And for those of you who write, I could have done better, that's what reflective practice is about. The association has one reflective practitioner group, and maybe there are other people who would like to form reflective practitioner groups where you can talk about what happened, and instead of blaming yourself, you can learn. So as I say to my own class, we do not agonize in this class. We analyze, try it out, see if it works. If it doesn't, we analyze a little bit more until we figure out the path that we want to take. And so do that for yourself. No tap dancing on your brain. Be as kind as you possibly can. Being a mediator is hard, absolutely hard. And if you want to learn more, oops, can I shut it down?
You can shut down the option. Do you want me to shut it down for you?
Yeah, so that I can move forward.
Yeah, there you go.
I just lost.
Yeah, did you want to shut it down, Ava?
Yeah, I can show the stuff at the end. Let's talk. Let everybody talk. And what did this sing to you? And where do you disagree? And if you absolutely, totally disagree, raise 2 hands so that I can call on you.
Or just wave.
Any here?
Thoughts? No? Any questions?
Chris.
Hi. Hi, Ava. Great talk. Thanks very much indeed for that. I have a question. I think probably the most interesting of the slides that you put up, interesting to me anyway, was that one where you showed different parties at different points along the chain.
Yes.
And that is really interesting to me as a practitioner, because it's telling me it's not just a theory of this, but it's actually giving me a practice. What do I do when? And a lot of my cases are 3-party cases. What do I do when all 3 people are on different points of the chain? Or what if my perception is that the lawyers haven't prepared well enough, and so they haven't, they're still at the first stage, and actually the other law firm are at stage 4 or 5. Have you got any more sort of tips or comments or reflections on how you deal with people that are in different stages of the process, and not just in relation to the one mediation? It could be in relation to one issue in relation to that mediation. There could be 7 or 8 aspects to the case, all of which are required to go down this chain.
There are 2 things I do. One is before, quote unquote, the mediation. I view it as part of the mediation, but a lot of people don't think the mediation until they're sitting down. I meet with the lawyers individually, and I listen to them for as long as they want to talk. I read whatever they ask me to read. And then I get all the lawyers together and say, it is my job as mediator to develop the process. How do you think we should settle this case? And I get them all involved in the development of the process, because that way they can relax. they can deal with their client's issues and not feel that they have to watch their back because the mediator is going to run amok on them. So that's one thing I do. The other thing I do is when it's clear to me the case is going to settle, but it's not going to settle today, I usually say to everybody, worked awful hard today. You agreed to this, you agreed to this, you agreed to this. The case is going to settle, but it's not today. What does he need to learn? What does he need to do in order to move closer to you? What does she need to do in order to move closer to you? And we assign each other assignments. I'd like you to meet my CFO. He has a lot of questions that you need to answer. I'd like you to blah, 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 and vice versa. And so they plan how they want to move and get closer to each other. Now, I don't know if you have that kind of freedom in the UK, but in some courts you do, in some courts you don't in the US. But it is the easiest to say, it's not going to settle today. It is going to settle. We all work too hard. It's been a pleasure to be your mediator. What do we need to do to help this case move along?
Mhm. I think, Phil, did you have a question?
So yeah, no, I just make an observation. I've got a background in business transformation and change, and very often we're trying to make some people move from a position where they were comfortable in how they worked and how their business was run, etc., to doing something new. And my experience of that, and I think it applies here, is that we go back to the basic human emotion of safety. The fight response that we have, that every decision we make is made on that. How safe do I feel? And we had a long time ago, I'm kind of name dropping, I was working with the chief executive of the Bank of Scotland, a guy called Peter Burt, and we had a discussion about decision making, and they all were of the opinion that no, our decisions are made on logic, and that's how we do it. We weigh it up, this, that, and the other sort of thing. And we did a quick exercise we won't go into, which they actually suddenly realized that they were making a decision based on how safe they personally felt making that decision. And that's what we've got people here, is they need to feel personally safe making that decision and making that agreement as they go forward. Just my observation of kind of how bringing what I learned in the business world into mediation.
Absolutely. And the way I put it is that grown-ups like to try something on before they buy it. They need to see if it's going to fit, and whether it's going to fit, whether they're sitting down or they're jumping or they're thising or they're thatting, or else they're not going to make a buy. And so, you know, anything a mediator can do to reduce the risk, to increase the safety, to permit people to move, it is going to be helpful to them. I know that we think about trust all the time, but trust is about the mediator. You know, and what we have to start thinking about is risk facing the parties, because the more we manage or help them manage their own risk, the more likely that they'll end up trusting us.
Yeah, Shelley, you had a question.
Yes, Nancy, hi. I just, it's more again of an observation, Ava, very interesting talk. And I love the language that you're using. And one thing in particular, I think mediators, by definition, if you are passionate about mediating, you just want to help. That's a really overriding factor in most mediators. You really do want to help people. And I love the way you say, don't fall in love with your own solutions, because that is an emotional language that you're using. We are impartial, neutral, and providing that safe space, and we're non-judgmental and we're listening, but we also have emotions which we try to curtail. They do play in. When we hear a struggle going on and we think we've identified what the struggle is and we've had this amazing epiphany and a solution, I know exactly what you're saying when you say don't fall in love with that. That's not for you to push. That's not for you. Of course, we're not there to say, well, I've got the answer X, Y, Z. We know well enough that they've got to come to the understanding themselves with guidance. But that is made me really think there, because you do fall in love with a solution. And it just made it very clear to me that's something to be very on guard about, because we're there to help, we want to help, and we think we've got a solution. And it's being very, very careful in how you approach that solution and don't fall in love with it.
Can I build on what you just said? If you have a solution and you think it's good, you can investigate a possibility. You know, and I have no idea whether it would work, whether it's a good idea, a bad idea, whatever. Can I just throw it on the table and hear what you all think about it and have them work it out for themselves? But again, they have to have a need first. You can't present a solution to people who don't know they're in trouble.
Yeah, agreed. Thank you very much for that. A lot of clarity. Thank you.
Anything else? John.
I'm just working out how to unmute. Thanks, Ava. Really good to see you. I want to build on Shelley-Ann and what you just said. Again, I come back to something I always come back to, which is we might have experience in our business works or how this relationship's working from our own life, but actually it's not that business and it's not that life or that relationship. We only see a small amount of what we see through the small conversations that we have, and therefore I find it really difficult, even though I might have ideas, I find it really difficult to sort of impose them because you don't know enough. The only people that know enough are the people that are there that are trying to sort it out. So I'm just building on what was just said there, really.
But I'd like to build on what you just said. And that is, in their brain, people often have a criteria list. It has to be this, it has to be this, it has to be this. And they don't question those criteria. I had a young person come to me and said, I can't decide whether I want to be a lawyer or I want to be an architect. My mother says this, my father says this, my uncle says this, my aunt says this, my grandmother says this, my daughter says this. And I said, whose life are we planning, yours or theirs? And she said, mine. And I said, and what do you say? She said, I don't know. And she was frozen. Had this been a mediation, she would not have known what to do. And so I said, well, you don't have enough information to decide. Why don't you one summer work for a law firm on development, and the next summer work for a developer and see what makes your heart sing. And she now is vice president of a development company because she gets to practice architecture, law, and everything else in between. So it's really a question of having them figure out what's making them run or stop, and to help them figure out where they want to go with their criteria and their needs.
And I think it's that important thing of being humble, that we may think we know the answer, but we need to put it out there as kind of a, you know, what do you know, correct me if I'm wrong, or here's maybe something that would work, but I don't know the situation as well as you know.
That's right. Because Nancy, so often someone says to me, what should I do? And I go, you know, I'm too busy messing up my own life to mess up yours. What's stopping you from deciding? What do you want to do? Do you know? Ken Webb has his hand raised. I see your hand raised, Mr. Webb. I will.
Well, actually, I'm raising it for someone else. I just noticed in the chat box a question posed by Lynn Phipps, and I am just dying to know I'm just dying to hear your response to it.
I'm being set up. Go ahead, Mr. Webb. What's the question?
She said, great questions to ask. Would you describe yourself as an activist mediator?
No, I would not at all. By which I mean, I have been coded, and I have been shocked sometimes at what kind of mediator I am, but activist has never been one of them. I have a tendency basically to do it by questions, giving information only when it is clear that I do know something. But by and large, you know, the parties created the problem. The parties can solve the problem. My job is to figure out how to do it. And I'll tell you, I settled a case that was like 20-something years old in our courthouse. And after the first meeting, it involved the government, corporations, blah, 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 in an Indian tribe. And at the first meeting, I said to everybody, I want to stop. This isn't working out. And I said, could I speak to the Attorney General of the tribe. And I said to him, sir, you've been settling cases for 4,000 years. How do you do it? And he told me how he did it. And I said, all right, sir, we'll use your method. And it's community organization. And I went back and I told the other lawyers, this is what's going on and what do they think about it? And they said, let's go for it. And so we all worked out a new system that was more consistent with the soul of the Indian tribe. And my attitude is that it's not us who decide how people should live. It's them. But we should be skilled enough to figure out a methodology that will help them decide what they want to do.
I just wonder whether Lynn meant the same thing as by activist that you heard.
Oh, possibly not. I mean, I understand that there are two very different languages between that spoken in the United States and in England. So what do you mean by activist? I should have asked. Thank you.
Yeah, I meant that willingness to help to actively steer the parties and help them towards the solution, which it seemed to me that is a lot of what you were doing, but it might not be the word that you would use, because there are different schools of thought about how much one should, if you like, help and steer and nudge the parties, or whether one should simply kind of stand back and wait for the solution to emerge. So it's kind of on that spectrum.
Then I am an activist. You know, I will.
That was my feeling, but I was interested to see how you would respond to the label as well.
Yeah, no, I basically view myself as a management consultant. I've had so many different lives, but I only do it by investigating possibilities or by asking questions that will help people figure out what they want to do. I try as hard as I possibly can to stay out of their dispute.
Mm-hmm.
I'll give an example. On construction disputes, very often it is very technical, given the quality of design, construction, and all kinds of legal issues. And I usually say, what's the likelihood of you working together again someday? Not now because you hate each other, but someday. And people usually say yes, and I go, all right. So instead of talking who shot John, why don't you talk about how this could have been prevented? If only I had done this, maybe this, so that you can create rules for yourselves. So next time you don't have a claim. People really get excited about that. And I told this to one person and he said it wouldn't work. And I said, all right. He said, but I'm going to try it. He called up and he said, 6 hours on what produced the claim, 25 minutes on how much money had to pass hands. So there are all different kinds of ways to settle disputes, which is why I enjoy having lawyers involved in the process, because they've had many more disputes than I've had.
So we'll come up to 7, and I know some people have to leave at 7. And I just...
Could I just ask Lynn, did that answer your question, Lynn? Did that question?
Absolutely. I mean, it reflects the discussion we've had and the presentation that you've made, but I just thought it would be worth asking. Thank you.
Thank you.
That's great. I just wanted to say before everyone left how grateful we are, Ava, to you for the talk and a different perspective and some practical tips, because I know sometimes you do think, oh, I know how to help them. And sometimes we just need to sit on our hands and zip our mouths, don't we? Thank you. So, yeah.
I must tell you, Nancy, I usually I have to sit on my mouth.
Sit on your mouth. So are there any more questions or have you got to go, Ava?
I'm here for as long as you all want. And
yeah, any
a lot of information. I just, if I can show my slides again, I don't know if I can.
Sure, just share screen.
Share screen.
Yeah.
Okay. There are books, and unfortunately, they're all written by my.
Yep, we can see them.
Oh, but I can't see them. How did you get to see them without me?
I don't know, but we can see them. Maybe it's hidden. So you're on the 7 prevention measures. Have you got anything else?
Yeah, it says next is if you want to learn more.
Yeah. So if you want to learn more, it's got the selling on it.
These are the three books. The one that Neil is most famous for is Spin Selling. It was #1 on the sales parade again for 30 years. I think now it's #2 or 3. But the book that I enjoyed the most is Major Account Sales Strategy. It's what introduced me to the decision-making process. And when I read it, I went, that's what disputants go through. And it just changed the way I mediate. And the other one is Getting Partnering Right, in which he went out and saw 2 companies, did all this kind of research to discover that if they shared impact, if they shared intimacy on problems and on data, and shared a vision of what they wanted the future to be, they could create, not within the settlement box, but outside of the settlement box, 2 + 2 is 6, 10, 20, whatever. And I thought that is a mediation skill. And I use that all the time in trying to get people to think, do I want to get back together in business? And if so, how can I do it? Very often I settle cases not by a settlement agreement, but by an operating agreement, so that people can work effectively together, and they do all the design. I just sit and ask hopefully the right questions.
Thank you. Because it's very relevant.
One more. My book. And so I want to thank everyone who ended up teaching me. Most of the people are British. Rackham, Hughes, and Huthwaite International is a British company in Sheffield. So
you want to talk about your research while we've still got quite a few people here, Ava?
I would love to. Ken and I have been working since 2017 to figure out what's going on in a mediation, not at the theory level, but at the nuts and bolts level, to try to figure out the bricks that people put together in order to come to yes. And so we have been coding disputes and their resolution. And it's a dynamic, and it's complicated, and it's hard. And we have been working out a system with Edgehill, the head of psychology there, knows about behavior analysis, is very much aware of behavior analysis, and he's going to be running the science of it. Huthwaite and Ken are going to be doing training on coding and on coaching, and looking for people who are willing to be coded. When I say coded, no personal information is collected at all, none. All we're doing is behaviors you use and to what end. You can see the sheet after we fill it out. All you see is check mark, check mark, check mark, check mark, check mark. Ultimately, once we get enough information together, we'll probably go computerization, and then you can do big data. You can look at sequences, you can look at techniques and all of the kinds of things, but we're starting early and slowly so that whatever mistakes we make, we can catch before they become catastrophic.
Thank you for that, Ava. And
is that fair?
That is very fair. Yep, good job. Thank you.
Thank you, sir.
So I'll just stop the recording now, but thank you so much, Ava.